I'm in the car, so this is the only time I can do this, but I wanted to quickly mention some notes as far as what I would expect the defense to say at the Kyle Rittenhouse trial for defense's rebuttal, their closing, after the prosecution has their initial closing. Now, based on the video I just shared, that should illustrate where I'm going with it, because I talked about the prosecution's likely close and what they were going to say at closing. So you understand their theory of the case and the way in which they're going to try to paint Kyle Rittenhouse as guilty and convince the jury not to allow him to essentially claim self-defense for the deaths in this case. So that's the most relevant portion. The other aspects of it aren't as relevant because you know what they're going to be. Obviously, the defense is going to come out and they're going to say, let's talk about what happened in this case. Let's run through the timeline. My client experienced XYZ. He was threatened by Rosenbaum. The next thing that happened is Rosenbaum had chased after him, threatening to kill him, trying to grab his rifle, left him with no choice but to fire. He then attempted to flee as people were pursuing him and trying to kill him. He was forced to kill X. He was forced to kill Y as they attacked him with this weapon or that weapon. All that stuff is pretty obvious. The key is going to be after that, because after that, he's going to have to address what the prosecution said. And that actually shouldn't be that hard. The way I would actually go about that would be kind of like this. So I would say, during the prosecution's closing arguments, you heard District Attorney Binger tell you how my client provoked these attacks. He told you all about how Kyle Rittenhouse, my client, has a propensity to provoke attacks with his aggressive behavior, using his weapon in dangerous ways that are not permitted by law, threatening people for something as simple as destruction of property, and property at that doesn't even belong to Mr. Rittenhouse, and property he has no legal basis to defend. You heard the prosecutor tell you that my client admitted on the stand that he aimed his rifle at this Yellow Pants man simply because Yellow Pants man was damaging a vehicle that again didn't even belong to Mr. Rittenhouse. However, District Attorney Binger seems to forget the rest of that testimony. He wants to paint my client's comments as admitting to pointing a rifle and aiming a rifle at this Yellow Pants guy. But let's consider what he actually said. If he's going to bring in my client's comments about his comments to Yellow Pants guy, he has to bring it all in. He said Yellow Pants man accused him of pointing his rifle at him with the green laser. Clearly, we all know my client's weapon did not have a green laser. The only time that any witness or video footage exists confirming the existence of a green laser was when the men stationed on top of the building were aiming the green laser at people, as we saw in Drew Hernandez's footage. If the Yellow Pants man was accusing Kyle of being on the roof and using said green laser, well, then he must be mistaken, because my client was never on that roof, and the prosecution has never put forth any evidence suggesting that he was. So, if the prosecution wants to say that when Kyle was on the stand, he said, "I did," in response to the question about pointing the rifle at him from Yellow Pants guy, that would mean that he admitted to being on the roof and using a green laser, something we know he didn't do. Clearly, his comments, as much as the prosecution would like to frame them that way, are not conceding that he indeed pointed his rifle at anybody to protect property, because he didn't. There's no video evidence suggesting that he did. There's no witness testimony suggesting that he did. That said, moving forward from there, they also explained how the single frame from the drone footage also shows him aiming his rifle at somebody. Unfortunately, that 1.5 second period that is purported to exist in that freeze frame image doesn't exist on any of the 150 video cameras or approximately 740 witnesses. Somehow, that's the one moment that escaped any witness seeing it or video camera recording it. They claim that that image shows my client was aiming the rifle at Mr. and Mrs. Zeminski. Yet looking at the frames before and after that photo, and if we look at the video here, I can show you this, we see that his alleged support hand as he held the rifle was a part of the vehicle that was there before he arrived. We can also see that it appears as if this figure, my client, according to the prosecution's suggestion, is holding the rifle in this picture lefty. He's a righty, he's not left-handed, and he doesn't have the experience to rapidly switch between right and left posture. That said, the footage itself doesn't show what they claim it shows, and the fact that 3 or 4 pixels can be arranged in a format that appear to represent the shape of a person holding a rifle certainly doesn't provide anything other than reasonable doubt. That's the very definition of reasonable doubt, and for that reason, you mustn't consider either the testimony that the prosecution alleges admits to pointing the rifle at the yellow pants man, or the grainy image that is purported to show my Kyle aiming the rifle again. You must not consider either of those as representative or indicative of provocation, because my client never provoked anybody, and there's no evidence to suggest he did. Certainly nothing that would justify convicting him beyond a reasonable doubt. For that reason, you must acquit and find him not guilty. That's, I think, how they should approach the provocation side of things. And again, they might still get provocation eliminated. It's possible. I believe the judge was going to send them jury instructions today. They might have sent some sort of an emergency motion to him asking him to reconsider. Oh, I dropped my phone. But I guess we'll have to wait and see what happens on Monday and find out. I know there's all